Hello, and welcome back to NPZ Law Group, Nachman Fulwani Zimochek Law Group, News and Views, Immigration News and Views, which we're trying to bring to you on a regular basis to tell you some of the nuances of various immigration procedures. Now, in the PERM labor certification process, many times we'll receive questions from clients or potential clients about whether or not it's best to do a case as an EB-2 or as an EB-3 case. And that analysis is a very complicated one. It's not one that you can simply answer right off the top of your head. We really need to look at a couple of different things. One of the things that we look at is what country is the individual from for whom we're doing the labor certification. And the reason why that's really important is because we have to take a look at what's called the monthly visa bulletin, which is promulgated by the U.S. Department of State. The U.S. Department of State puts out a visa bulletin every month, and that is available to you on our website. We invite you to take a look at our website on a monthly basis. And you'll see, if you look at that website, that for certain countries, such as China and India, there are backlogs in the EB-3 and EB-2 classifications. And what that means is that individuals may have to wait a longer period of time to process an EB-3 employment-based visa application, whereas in the EB-2, they may not have to wait as long. So oftentimes, our Indian and our Chinese clients will say to us, please do an EB-2 case. And we will say, well, in order to do an EB-2 case, we have to prove that you have the equivalence of what would allow you to do an EB-2 case. So what is that? Well, if you have a master's degree, then of course that would allow you to do an EB-2 case, and that can be either a U.S. master's degree or it can be a foreign master's degree. Or what you can do is you can use a bachelor's plus 5 years of experience, and that experience has to be post-bachelor's degree. And if you have that experience, then what you can do is a bachelor's plus 5 is equivalent to what you would need to do to have an EB-2 case. Now, the advantage of an EB-2 case, again, is that those cases will tend to go faster. In the employment-based arena, you'll tend to find that the higher levels of education tend to be those cases that move faster. Now, what we'll often try to do for a client also is to take a look at their resumes and see whether there might be options which allow them to do what's called pre-certification. Pre-certification means to avoid the labor certification process altogether. The PERM labor certification process has that additional bureaucratic overlay of dealing with the U.S. Department of Labor. However, if we take a look at the resume and we're able to determine that there's an opportunity for our client to pursue maybe self-sponsorship through a national interest waiver or through an extraordinary ability classification in the EB-1, or whether there might be some other option that could bring them into a pre-certified classification, we're going to try to do that for them too. So that concludes today's observations about the green card. I'd like to thank you very much for joining us, and please come back for additional information about employment-based immigration and business procedures. We here at NPZ Law Group would be more than happy to assist you with any of your business and or family-based immigration needs. Thanks very much, and goodbye for now.